to avoid when you file your case with USCIS. In this video, we are going to lay out some foundations for you so that you might be able to respond correctly to requests for evidence and to intent of notice to deny. My name is Bijoux Ngwanda. I'm an immigration lawyer based here in DC. However, I do have clients across the country and around the world because we are dealing with complex US immigration law cases. If you're new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing, and please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like, don't forget to comment below. Also follow me on all platforms. Links are in the description box below. The number one mistake to avoid is to respond to requests to evidence without a consultation. That's a number one mistake to avoid. Why? Because when you schedule your consultation with a qualified immigration attorney, they might give you some hint of what you can do exactly under your circumstances. We have a case. This is a consultation I just had, I believe yesterday, with a client who responded to a request of evidence without a consultation and without doing proper basically research in order to respond to USCIS. And then her immigration case was denied. Green card application was denied. And guess what? The only thing they asked her is to produce a birth certificate. But she didn't know how to go about it. First of all, this client has an asylum case pending with USCIS. Then she goes ahead and marry a US citizen, okay? And when you marry a US citizen while your case is pending, those are two distinct cases, right? You still have to produce your birth certificate. In some circumstances, you can actually explain if you cannot get the birth certificate. But this is a country where if you go on the state.gov, okay, website, it's going to tell you exactly how to get a birth certificate for that country. And on the state.gov, they give you instructions and they give you what form is available in case the birth certificate is not available. What form or what exactly can you do? What document you can present to USCIS in order for them to accept it and consider that specific document as a birth certificate in lieu of the actual birth certificate. This person, they didn't know that. They didn't know that because, number one, the mistake they made is to not consult with an immigration lawyer. It was so clear on the website. They could have just done the procedure and asked the authority, the issuing authority in their country, to produce the birth certificate. Or they could have explained that their case of asylum is pending, therefore they are not really required, as for USCIS policy, to produce a birth certificate. But you have to really give an explanation, a solid one, for that one to actually work out. But if they had just gone really with that instruction on the State Department website, they could have really saved their application and get their green card. Now the green card is denied. They have to file the form, as you know it, I-290B, to actually appeal or motion to reopen, right? Or to start over, really. But you know what? This is, instead of just doing a consultation and avoid that, now they're going to pay for the consultation and pay for the USCIS fees if they have to start over with the green card, or if they have to file that form, you still have to pay for those USCIS fees. That's the number one mistake to avoid. The second mistake to avoid is to work while you are on a B visitor visa for pleasure. If you come with a B visa as a tourist, you are not allowed to work, whether it's unpaid or paid. You just are not allowed to do it. Some people think that if it is not a pay type of position, they can just go ahead and do it. No, you cannot. In order to do an internship, you have to get a J1 visa, intern type of visa, in order to come and do an internship as an exchange type of program. But if you are on the B visitor visa for pleasures, you cannot do that. You cannot work, pay or unpaid, just period. And one thing to add about that is that, however, based on this new policy that came out last year, you can actually apply for jobs, right? You can apply for jobs, you can go and attend interviews, but you cannot work. So meaning what? Meaning that when you apply for jobs, they call you for the interview, you go do your interview, and if the employer decides to hire you, they're gonna have to go through the process, whether it's under B2 type of green card, or EB1 or EB3, or just a work visa. In terms of if you're Canadian, it's gonna be TN, those type of visa, right? Or a Mexican, they have their own specific type of work visas. Really, you just have to go through this process. The employer has to go through the process of applying for a work visa. That's it. You cannot work because that's a mistake. And this one happened to another client who had a consultation, I believe, the day before yesterday. That's just, again, about working while on a B1 B visa for pleasure, like a tourist type of visa. Because we have another one, that's the B1 for business. That's where you can come and consult, negotiate a contract, and so forth. But that's for business, it's specific for business. But this one really, if it's for tourists, you just cannot. Now, the person is in violations, right? Or non-immigrant visa. First of all, they just have to stop right away. And eventually, if it's been asked on the application, they just have to disclose those facts. Otherwise, it becomes, again, misrepresentation. Can you just be lying to an officer if they ask you if you work in the United States? You can explain yourself on pay, but still it's work, right? Number 3 mistake to avoid, and lastly, this is a mistake really a lot of people make as far as applying for U.S. citizenship. If you're applying for U.S. citizenship, you have to check if you qualify under good moral and character. If you do not qualify, you have criminal record that happened for the past 5 years of your statutory period, you just have to wait, right? Another 5 years for you to actually apply. Even if it's waived, it's better to wait because you don't know. Some type of waivable offense are still going to disqualify you because it happened within that 5 years statutory time. Let me know what you think in the comment. If you need a consultation, again, you should schedule it by using the consultation link in the description box below. And especially if they ask you to produce evidence, requests for evidence, or notice of intent to deny. That's when they actually give you the opportunity to fix your case once and for all. So again, please consult. Always do it prior to filings. If you're doing it in mid of filing, it has to be when you receive notice to request for evidence, or notice of intent to deny, notice of intent to revoke. Any type of notice you receive, do the consultation prior to filings, okay? Until next time, bye-bye.